Okay, we're live. Great. All right, good evening, everyone. Thank you for joining us either in person or online. The first thing we'll do tonight is approve the minutes of our last meeting, which was August 19th. The minutes were distributed. I think everybody got a chance to take a look at them, so I'll make a motion to approve. Do I have a second?
Second.
Judd, I'll start with you, Rosie.
Yes, approved.
Yes?
Yes. I wasn't at the meeting.
Okay, well, three of us is enough, so we will say yes to the minutes. And move on to the new matters in front of us. I think we're gonna take them in reverse order. So let's start with James Lundy, 17 Willow Street. Is anybody here on that?
Yes.
All righty.
Good evening. How are we all
Hi.
doing tonight?
Very well. How are you, Doug?
I am very good. I will share my screen so we can discuss the project.
Okay, excellent. Thank you.
So my name is Douglas McClure. I'm the architect for the Lundys. This is the wrong project. Hold on one second.
Alrighty.
I'm confusing myself. All right, give me a minute. I thought I was all prepared.
You've got a minute.
Either watching a baseball game or practicing.
So, this is a little embarrassing. I'm usually so on top of this.
Yeah, don't worry about it, Doug. Give me a minute to look this over again.
That should be better. All right, there we go.
Excellent.
All right, so again, I'm Douglas McClure. I'm the architect for the Lundys at 17 Willow Drive. The project is fairly simple. We're taking a house that has been in Irvington since the 1920s. The Lundys have lived here a very long time. The family originally built this house. And we are looking to expand about a little over 6 feet on the back of the house. So this is the house as it is right now, although the fuel tank has been removed, and we're looking to add this area over here. As you can see in my drawings, let's get rid of this. The house itself is located right. Yeah, it's this property right here. No, come on. This property right here. Like all these properties, a lot of them are already pre-existing non-conforming for the site, either in coverage or FAR or both. And so in my little chart over here, I have sort of gone through the areas of neighboring properties and highlighted the projects that are similar. We are we are currently at 109.1% over the existing, and we're
Currently.
proposing
Right.
for FAR. Yeah,
Right.
and we are proposing to increase that FAR by to 31.3% over. And then in coverage, we're currently 115.2%, and we're looking to increase it 19.5%. Those numbers might seem like a lot in when you look at the context of the area. It's very small. As I said, it's only about a little over 6-foot addition on the back.
Doug, just give me that FAR number again, if you don't mind.
So the allowable is 2,150 square feet. The current actual is 2,345 square feet, which is 109.1% over.
Okay. And you are
We are
proposing-
increasing it to 2,824 square feet, which is 131.3% or 31.3% over allowable.
Could you just I'm having a little bit of trouble seeing that chart. I just want to get a better look. Could you make that a little bit bigger? Yeah. And maybe let us see the top where we're talking about Willow Street, if you don't mind.
Okay. I got to find that balance between fitting on the screen and making it visible.
Right. Yeah, no, I hear you. That's much better. All right. So for FAR, you'd be in the top third of the top. And in terms of, is that coverage, that first column, or I'm sorry, is that coverage or FAR?
FAR is on the left.
The FAR
that's what I
FAR
thought.
is
So
on
you're
the left
talking,
and coverage is on
You
the
know,
right.
the top third, right?
Yeah.
There would be two properties higher, but you'd be up there. And in terms of coverage, you'd be kind of right smack dab in the middle, I would say.
Yes.
No, that's correct.
Yeah.
Yeah.
Okay.
And just to point out, the property next to them here, right next to them, if you just looking at the graphic on the site plan, you can see it's a double lot, but it's a substantially bigger building. And has a substantially bigger presence on the street. We're not changing the look of this building from either Willow Street or Oak Street. It's just getting a little longer, so perceptually it won't feel like a giant building suddenly being dropped into the lot, if that makes any sense.
It does. And what's the point of the addition? What's the addition?
So hold on, I will get to the plans. Why can't I get to the plans? Here we go. So, starting with the upstairs, these older houses had much smaller rooms, but also there was only a single bathroom. So we wanted to add, essentially turn the existing bathroom into a master suite. Then increase these bedrooms a little bit and provide a hall bath for both of them. That's a big part of it. So a family can live there with a little more comfort. And then downstairs, I can't turn that off. We've increased the kitchen and made the kitchen sort of more central to the house. Taken this big space over here, which is sort of just a very large space, we're actually not expanding that at all, but making it more of a scalable dining room and an office, and then adding a little mudroom space. So this whole addition in the back is a little bit more kitchen and a mudroom area from the side entrance.
Anybody else have any questions?
Doug, for the side yards, as
Yes.
far as the variances with the coverage, the FAR, but to go over the height and the side yard variances.
Sure. So the side yard, the house is currently as it exists is in violation of the side yard. And we're not changing that violation in terms of encroaching more into the side yard, left or right. We are pushing it, we are extending the violation backwards, but we're not making it worse than it currently is. We're not bringing it closer to the side yards property lines. And then the height variation is sort of the way the code reads, we have to take the height from the street. And because this is sort of up on a hill and this garage is down low, even though the house itself is really only this tall, I have to actually take that extra piece. So again, it's not making the height variation worse. It's just keeping it in the same height that it is now.
Right, so Doug, I was there, I looked at the side yards today and they are really narrow, so there's not gonna be any, we're not gonna see like, a proposal for a mini split in a year or 2 years in the side yard, right?
No, because what we have is, and we can locate it anywhere in the back, but we do have this covered area existing under the house that I could tuck it into, and it would be under the roof and tucked away.
In the back.
And at the back end of the house, yeah.
Okay, great.
Okay. Is that part of the plans now or just something that could potentially?
We have not met with a HVAC person to discuss. We have to do a whole new HVAC system. So my assumption is that's where it will go, but it might be, be in the back. Until I know what I need, I can't really tell.
Sure. Right.
I didn't like it might be in the back.
Well,
Yeah.
Right.
Well, it really depends on the size of the unit, right? So I can't imagine it not fitting in this area. But if it's two condensers, I keep forgetting how to use this. Would I have to put something in this area? Come on. In this area instead? It's actually not where I would want to put it. I don't know what the pieces are, so I can't really say. But my feeling is it'll fit in that first area.
Is that first area that you mentioned already included in the coverage calculations?
Yes. It's a covered. It's a covered area now.
Right.
There's a roof. The roof goes over it.
Yeah. I mean, I guess all I can say about that is that if you were to come back to us for something, we would look very poorly upon putting it in that side yard area. I agree. Those areas are really tight. And
in this,
do your best.
Okay. In this, would it be problematic sticking it in here?
I don't think so.
I don't think so.
Okay.
Yeah.
Right.
Yeah.
Sticking it over here is a no-go.
Right.
It's a no-go for me.
Yeah.
I live in the village. I know what it's like to have
Sure.
it right on your line. So
Right.
I totally agree with that.
Okay.
Okay, good.
Any other questions? Anybody want to be heard on this, Sarah?
Nobody's raising their hand to speak and there are no comments in the chat.
Okay.
Can I ask one question, Doug, just
Yeah.
to confirm? The home and back on Willow Street, right? Or I'm sorry, on Oak Street, looking at Willow to the west. Will the height, it will not change or impact the view, just to confirm that?
No, I actually have that here, I believe. Hold on one sec. So the house comes, this is sort of hard to explain. Perspective wise, the house comes towards you a bit, but it doesn't really affect the view in any way. And actually, the house, I'm standing in the yard of the house right across, which I did the addition for. Those neighbors are actually very excited this is getting done because they would love to see the house cleaned up. So, but it really does not affect the view in any substantial way.
So this is the view from Oak Street looking west.
Yes.
All right. Well, I'm gonna make a motion. I mean, obviously, we've dealt with this neighborhood before and we know that they're all pre-existing, non-conforming, so we're gonna be going over on FAR and coverage. And the side yards. I mean, those are kind of a given.
Yeah.
But I don't think this is a big ask. I think, it's gonna be a big benefit to the homeowner without a huge detriment to the neighborhood. And so I will make a motion to approve. Second,
Yep.
Charlie, and we'll start with you.
Aye.
Yes.
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 Okay, you're approved. I'll send you a letter this week.
Thank you very much. Have a wonderful evening.
Thank you.
And come enjoy Halloween on North Dutcher Street.
Thank you.
Bye-bye.
Bye-bye. All righty, so that brings us to the only other matter tonight, which is Irvington Neighbors Against Traffic. Do we have somebody who is appearing on this?
Yes.
Great.
Good evening, Madam Chair. For the applicant,
Yes.
how are you?
Good. How are you?
Good, good. Thank you for hearing us tonight. I'm representing the applicant. My name is Darius Shafazada. I'm an attorney at the law firm Harris Beach, representing Irvington Neighbors Against Traffic LLC related to an appeal from a decision made by the building inspector on August 6th, 2025. We have filed the application timely in accordance with the code and concerns 76 North Broadway. We submitted a letter and a very detailed application. This is an appeal under the Village Zoning Code, specifically Section 224-97, subsection A. And we've laid out our position in our papers and our appeal papers. Essentially, ladies and gentlemen of the board, the issue that the neighbors have is that the proposed use of a daycare center is illegal under the zoning code in the district where they're proposing to build the daycare center at 76 North Broadway. We've laid out the interpretation cited to the federal law, cited to the state law, and we'd ask you to determine that the decision by the building inspector on August 6th was improper, that the daycare center is an illegal use under your zoning code. That's the nutshell. Be glad to answer any questions about procedure, about substance. That is or is not in our submission.
Yeah, I mean, to me, the big thing that's missing here is just something to appeal. I don't see a decision by the building inspector. So I'm not sure what we could possibly do at this point in the proceedings. I mean, presumably, eventually there will be a decision by the building inspector, but we get pretty standard packages, and the first thing we usually get is a letter from Ed saying, you've been, you're not giving a building, help me out here. I'm losing my words
Building
here.
permit?
A building permit, because of the X, Y, and Z reasons, and then we hear an appeal on that. And I just don't see that in front of us.
Well, the appeal is from the statement made at the planning board meeting to say we're between a rock and a hard place.
Right.
We've asked the building department, we've asked the village attorney for the building inspector to make a decision, whatever it is, on use. His decision is his decision. The project has been before the planning board for some reason for months now with no written decision being made. So at the August 6th meeting, there was arguably a comment made about the use, really made by the village attorney and the planning board chair that has no authority on the issue of use. So what do we do? How does a project go before the planning board for almost a year or more without a determination on use, which is the first issue that has to happen? So
Yes.
what do we do as neighbors? We have to appeal the statements made at that meeting. If there's an actual written document, then one should be written, whatever it is. I don't know what his decision is. It sounds like he thinks it's a permitted use. Maybe he doesn't think it's permitted use. I don't know. But we're getting held hostage by no decision potentially being rendered. So if we don't appeal some statement that he makes, someone may argue in the future, oh, they're too late. They didn't appeal the issue. So the real question is, if a decision wasn't made, why isn't one being made?
Yeah. I mean, I don't disagree with one of the things you said, which is maybe he thinks it's a permitted use and maybe he doesn't. I agree with that. He just hasn't let us know. And because he hasn't let us know whether he thinks it's a permitted use or not, there just isn't anything for us to decide. The only thing we can do is when the building inspector makes a decision to issue or not issue a permit, we can then make a decision based on that, but there just isn't anything. I know the comments that you referred to because I read your papers. And it was an opinion expressed by the village attorney. Now, usually the building inspector could take that into consideration. We could take it into consideration, but that's not a decision. That's a piece of advice on her behalf, but it hasn't led to the decision. Now, and I can tell you honestly, I have no idea how long things are in planning board. I know they're often there for months. I don't know what the average is or what is an extraordinary amount of time. All I know is they have to be done with the planning board process. They are issued or not issued permit by the building inspector, and then that's the period at which we get involved.
Well, the planning board reviewing an application that is illegal on use, that's sort of the problem in the village that I know is being discussed all over with land use committees. The decision on use is the first thing that has to happen before anything goes to the planning board or anywhere. You go through a year at the planning board and say, yeah, this looks like a good project when it's illegal. That's not the way it really works and should work. That's why we've been begging over the summer and in the spring, make a decision. Is this legal? We think it's not. So we have to wait for years and years and years when secret review gets done by the planning board with no input from your board. That's the problem with what's happening in the village is there's no set guideline of how a use issue is determined in the first instance, which is issue one.
Yeah, I mean, I understand the frustration of you and everybody who's here tonight, but by the code, by practice, by everything we do here, we only hear appeals from written decisions by the building inspector that are sent to applicants, and then they come to us to appeal them. And that's just the way this process works. Sometimes people are before the planning board for months, they get rejected, they come to us and we say no, and then the whole thing starts all over again. So this is not whether or not
this
it's
may be a
right,
committee discussion. This may be a committee discussion of how it works, but there was a statement made by the building inspector, I believe, at that August 6th meeting. There are filed minutes of that in the village clerk's office, which we present is the decision. If you're determining that it's not, that's up to your prerogative. But I think, it's kind of a little backwards to say, let's go through an entire site plan review for a year and a half or two and then decide whether something's legal or not. That's common sense, and that's basic 101. But I seem to be, my statements seem to be falling on deaf ears, despite how potentially reasonable they may sound.
Yeah. And just as I said, we need a written decision from the building inspector to permit or not permit the building. And that's where our role becomes relevant. And it's really a very narrow role that we play. And that's when we get involved. So we need something to appeal from the building inspector that is written out to us and sent to the applicants. Does anybody else have anything to add? So,
Just on
So,
for the applicant, can I ask for like a decision on that your determination is that there's no decision made by the building inspector after your review of the record submitted, and that as a result, you're finding that there's nothing to appeal, so we have our rights protected?
I mean, I really don't think I can say that. I can say that this is not properly in front of us because we have not received the proper paperwork from the building inspector issuing a decision.
Yeah, is that
So
the
there's
motion by the
nothing,
board?
there's no motion to make. I'm not going to make a motion. There's no motion to make here because we don't have a decision in front of us that is appealable. And I don't have anything else to add, I think, at this point. Does anybody else? Yeah. I'm sorry, I hear your frustration and I understand it. This is not the first time I've heard frustration at a zoning board meeting. But that's the process we've got before us at this point, and there's just nothing for us to do here tonight on this issue.
Okay, thank you for your time.
Okay. No,
We
thank
could
you.
agree to disagree.
Yes, exactly. Exactly. Thank you.
Thank you.
And I think that is it for us tonight.
Motion to adjourn.
Motion to adjourn. Thank you. Have a second? All in favor? Aye. All right. Thank you very much. There's just nothing for us to do here tonight. Like there's
Some
just,
questions that
but we can't answer them because we have nothing in front of us. We just don't have anything in front of us that we can do
you
anything
said that
with.
there's nothing here this isn't ripe for appeal. So one of the questions would be, when would it be ripe for appeal?
When the building inspector issues a permit or a decision not to issue a permit.
So the planning board is the party under the code responsible for issuing a special permit in connection with any development that takes place in the MFO district. So it's the planning board that issues the permit.
The building inspector is the only way, every time any of us, the planning board or us, send out information, we always say, this is not in lieu of a building permit. The building permit is the final step, and that's what needs to be issued before we can act.
So if the planning board, so the process that has been set up by this MFO district law, grants the special permit to allow for the project to move forward, and ultimately the building inspector may get around to then issuing a building permit. The issuance of the special permit by the planning board, is that create a time from which we can?
It's the building inspector, when the building inspector issues or doesn't issue a permit, that's when, and he writes a letter either way.
But the code doesn't
That's,
say that. The code
With
says that,
respect, I don't think.
the code says
board
that there's
should be
a-
issuing legal opinions to,
excuse me, I'm speaking.
well, with respect, I don't think it's the board's obligation to give you legal advice.
right, there's just nothing, and that's just the way that our process works, is when the building inspector issues something, we can look at it, and there's just nothing else I can tell you about that. That's just the way it is.
Seems like the statute provides for alternative ways for you to act. Like there is, as part of the application, it says you can request interpretation.
Of a written termination
written-
by an administrative official.
Termination by administrative official.
Right, a written determination. It's got to be filed with the planning board within 5 days. Right, we don't have a document. I mean, it's, that's what the state village law says. Written determination, 5 days.
The question becomes then, if the planning board issues us a special permit, which is the way the statute is designed, does that constitute a written determination?
I don't know.
That's great. So this whole thing could go forward without anyone looking at the question of whether it's a permitted use until after the building permits have been pulled, and then you'll have a look at it, and then what happens? I mean, that's remarkable. That's the position
the way
that
it
puts this
works.
village in.
In every case that
This,
we address, that's the way it works. This may be a somewhat unusual situation, but that's the way it works.
will be unusual. Because you're going to be looking at the permitted use question at the time they're pulling permits, and they may not be able to move forward. And they'll have spent 2 years and millions of dollars, and will be all for naught if it turns out that it's not a permitted use, which we strongly believe is the case. Just want to make sure everybody understands what's going on here. There won't be any surprises when this will be taken up on appeal here at some point, and maybe beyond that. Okay.